May it please the court, my name is Stitt, initial MJ, and I'm instructed by Mathis & Co lawyers, and I act on behalf of the applicant, Ms. Kylie Truman. This is an application for the interim orders number 1 and 2 on the initiating application by Ms. Truman. I'm seeking leave to read and rely upon the affidavit of Ms. Kylie Truman, affirmed on 19 September 2019, and the applicant's financial statement summary, which I tender. Your Honour, before we commence with the background of the matter, the applicant wishes to raise 2 objections in relation to the respondent's affidavit sworn on 19 September 2019. The first objection is in relation to paragraph 5 of the respondent's affidavit, particularly where he states, "The applicant is not any good with money, and if she gets her hands on any of my winnings, I fear that she will spend it on things she doesn't need." It's the applicant's submission that that statement is a matter of opinion and is therefore inadmissible. The opinion is one which cannot be validated and the respondent is not qualified to give. The second objection is in relation to paragraph 6 of the respondent's affidavit, and that's just on the basis that it's not relevant. If I can now turn to the background of the matter, the applicant and the respondent were in a de facto relationship and were living together in a rented apartment in Queensland for the past 10 years. The applicant has not worked in paid employment for the last 5 years, as she manages the home, takes care of all household affairs, and she volunteers at a local church for approximately 8 hours a week. The respondent works as a boilermaker in a large engineering company. The applicant and the respondent have a joint savings account which contains approximately $30,000. They have a joint check account and a joint credit card which they both have access to. If I can now turn to the events which are at the centre of the application and take your honour to paragraph 7 of the applicant's affidavit. The applicant explains that the respondent has been part of a lotto syndicate called Us Boys for the past 3 years. The syndicate was made up of the respondent and 10 colleagues, and the applicant was aware of the syndicate and was aware that they'd had small winnings from time to time. However, she herself was never a member of the syndicate. It is not clear exactly where the funds that the respondent was using to purchase the tickets was coming from. If Your Honour would turn to paragraph 9 of the applicant's affidavit, you'll see that approximately 2 weeks ago, the applicant found a bank statement with the respondent's name on it and showed that the respondent had deposited $400,000 approximately 3 months ago into a separate bank account. The applicant confronted the respondent when he got home that night about the money, and the respondent told the applicant that the syndicate had won the money and that was his share. The applicant then asked the respondent why he did not tell her. He replied stating that she would have wanted to buy a house with it and that it was he'd paid for his share out of his own wages. The morning after the confrontation, the applicant and the respondent separated. The applicant relies on 2 cases. The first is Zeke and Zeke, 1995, Family Court of Australia 135. The facts of that case were that the husband was part of a lotto syndicate since the 1970s. The syndicate won a major prize in 1987 and the husband received $94,907 as his share of the winnings. The lottery tickets were purchased by the husband from his own money, and the proceeds from the winnings were then handed to his wife, who applied it so that it therefore formed part of their joint property. In that case, the court found that the preferred approach was to consider the winnings as a contribution rather than a windfall. However, the court made it very clear that the specific facts of every case should be considered when determining which approach to take. In this case, in paragraph 50, the court found that where parties were in receipt of income and their marriage was predicted upon the basis of each contributing their income towards a joint partnership as constituted by their marriage, the purchase of the ticket should therefore be regarded as a purchase from joint funds in the same way as any other purchase within that context would be. The court further went on to say that this also applies where one party is working and the other is not. This is because this is the mode of the partnership which was selected by the parties, and the income of the working member is treated as joint in the same way as the domestic activities of the non-working partner are regarded as being for their joint benefit. The second case that the applicant seeks to rely upon is a matter of Anastasio, 1984, Family Law Courts 91-093. The facts of that case were the parties were still married and living together at the time that the husband came into possession of the $60,000. The money used to purchase the ticket came from the husband's earnings, and like the case you have before you today, Your Honour, the parties in Anastasio were wanting to buy a home together. And the inference was drawn by the court in that case that the purchase of the lottery ticket was an example of the parties attempting to acquire funds to enable them to do that. The court therefore found that the winner of the lottery ticket should be regarded in the same light as any other asset acquired by the parties during a marriage and distributed between them in the same proportion and in the same manner as any other asset. If I could now turn to my submissions. While there are some distinguishing features between these cases and the present case, such as the parties being married, for example, the general considerations of what the relationship was like at the time the ticket was purchased and the contributions made by either party to the relationship can and should be applied here. It's not contested between the parties in relation to Order 1 that the geographical requirement under Section 90 SK of the Family Law Act and the total length of the relationship between the applicant and respondent as stated in Section 90 SB of the Family Law Act are both satisfied. The court will therefore have no issue in making an order in relation to the alteration of property interests under Section 90 SM of the Family Law Act. The applicant submits that the court should make an order to alter the interests in the property being the winnings of the lottery that the respondent received, to include the interest of the applicant as it is just and equitable to do so. The applicant says that it's just and equitable to do so for two reasons. The first reason is the level of contribution to the welfare of the relationship through the non-financial contributions the applicant made. The second is through the current and future needs of the applicant. In relation to the contribution, Ms. Truman's affidavit from paragraphs 2 to 5 sets out a number of examples of her non-financial contributions. The first is that it was the applicant's flat that became the home for the couple. The respondent moved in with her. Since being unemployed, the applicant was the manager of the home and household affairs. This included being responsible for all shopping, cooking, washing, ironing, and cleaning of the home. These non-financial contributions were in fact acknowledged and accepted by the respondent in his own affidavit in paragraph 2. In relation to the current and future needs of the applicant, we submit that the applicant will find it hard to re-enter the workforce as she's been unemployed for such a long period of time and she's therefore lacking in experience. She also currently has no funds of her own as she hasn't been working and she's been relying on the funds in that joint bank account. Therefore, for her interest to be recognised and protected, it would be just and equitable to do so for those reasons. In relation to Order 2, an injunction should be placed on the joint funds once the money has been put into that account in order to prevent the respondent from spending any more of the winnings before a final order is handed down. The applicant has an interest in the winnings and that interest should be protected. The respondent has admitted in his own affidavit to having already spent some of the winnings on a small plane and beginning flying lessons. That's in paragraph 7 of his affidavit. He states that he's not sure how much of the winnings remain, but one can determine from the respondent's financial statement summary that he's spent approximately $16,000 so far on the deposit for the plane and the flying lessons. So this leaves approximately $384,000 remaining to date. Your Honour, our ultimate submission is that the parties were in what appears to be a stable and happy de facto relationship at the time the lottery ticket was bought and at the time that the money was won by the respondent and his syndicate. It's conceded that the respondent was the financial provider of the relationship. However, the applicant's household and domestic contributions to the welfare of the relationship we submit are enough to satisfy the court that she is entitled to a share of the winnings. This is consistent with comments that were made by the court in Zeke and Zeke. It's our submission that it is just and equitable for the remaining funds to be deposited into that joint bank account and that an injunction be placed on the access to that account by the respondent in order to preserve what's left of the winnings so that can be appropriately assessed and apportioned between the parties. Those are the submissions from the applicant. May it please the court.